लिखिए जनाब. There have been numerous. I begin in this concluding order of the hearings on a sad note. First off, during our trainings and pupillage with senior counsels, we were trained never to interrupt a judge once he starts dictating an order. We were trained never to speak over a judge. We were trained even if you did not agree with even a word of what the judge was deciding. Respect the court, hear the decision, and then exercise your appellate remedies. In this hearing, even today, which was live streamed even today, the people must have seen a reprehensible spectacle with senior counsels speaking over the judge, engaging in an incessant dialogue with him, and not stopping despite being told by the judge thrice that he was about to dictate the order. It is very unfortunate and time for us to mourn where the decorum is headed and what the new and upcoming lawyers are witnessing as probably stellar performance events by senior counsels. They must know that this is not, that what they saw, they must erase from their memories, and if they cannot, then to remember it only for a manner of conduct which they must endeavor never to repeat if they are to maintain and redeem the respect that their profession is supposed to bring to them. Full stop. Next paragraph. Today is the 42nd hearing. The reason it came to the 42nd hearing and was not disposed of on the 3rd was the fierce resistance by the respondents to the almost final order passed on dated so and so, directing the constitution of the commission with defined TORs and its membership, subject only to the government reverting with further instructions, to the learned attorney, additional attorney general reverting with further instructions from the government. This case is an atypical case in which only a direction is sought to the federal government to constitute a commission if the conditions specified in the act were met, and if those conditions were met and the federal government was still not constituting the commission, then that would be in terms of Article 199, 1A of the Constitution, failure to act in accordance with law or to perform an act which the federal government is required to perform under the law. I am rather stunned with this stance taken by the respondents, several respondents' counsel, that this court has no jurisdiction to pass a direction to the federal government to constitute a commission. This argument, in its essential character, would rub across all constitutional petitions where a relief is sought to direct the government to perform an act which it was required under the law to do. First, in view of that stiff opposition, the court in this atypical case had to see whether there existed sufficient circumstances which would alert a government to the need for the constitution of a commission for a deeper probe into the possibility of an unholy alliance between some persons and some officials of the FIA, resulting in the emergence of a pattern common across several FIRs, if not all of them, leading to the possibility of an underground alliance that may be entrapping people into acts of blasphemy which they walk into unwittingly and without a genuine intention to commit blasphemy. This was all that this court had to see. It did not have to determine whether the blasphemy gang actually existed the way it did. It was alleged. It did not have to determine whether the actual entrapment took place, and above all, as has been portrayed quite incorrectly, it never had to determine whether the accused in those particular cases, in those FIRs, were actually guilty. The entire scope of these proceedings had been pre-registration of a case or during the investigation, but before the trial began. This point remained lost on the respondents throughout, who could not see the distinction between the actual return of guilt, return of a verdict of guilt by the trial courts versus the existence of some gang which might be drawing financial or other benefits by using the ferocious sweep of the blasphemy laws and how it has been used in the past. Therefore, the onus rested primarily on the petitioners to show to the court some instances which lend credence to the NCHR's report and the special branch report of the existence of a pattern. Once that onus was discharged, because it was not a contest between two private parties, as is usually the case, and on the analogy of which the entire case was argued by the respondents' counsels, once the onus was discharged by the petitioner, then the stage to rebut that onus would not be before this court. but would be before the commission. Because this court is not to decide whether a black gang actually exists. It is the commission which will decide. From what I have heard so far, I am of the view, I have not दिखाई है मुझे, फाइल दिखाई, फाइल कहाँ है? From the on the 46, 42 hearings, but you know लिखिए. From what I have heard, since the 7th hearing has only reinforced the conclusions that I had reached in the 7th hearing when the order dated 31st of January 2025 proposing the constitution of the commission and its TORs was it on that? Yeah, and its TORs were suggested for the consideration of the government. The hearings, the number of hearings, that order was passed on the 7th day. On the 42nd hearing, I do not see if I can do any better, but to reiterate that order and to hold that anything that the respondents' counsels would have to say to rebut the circumstances presented by the petitioners is best said before the commission. But the final finding has to come from the commission and not from this court. Full stop. What the petitioners' counsel have done is show to the court certain linkages between the petitioner's counsel was asked to identify 5 most glaring instances that they would rely on as reinforcing their claim of the existence of a gang and a pattern of entrapment. Since I am deciding this case today, since I am passing the directions today for the constitution of the commission, I will follow up this order with a supplement that would simply summarize the linkages between those FIRs, the pattern that emerges to justify the constitution of the commission, which can be looked at by the commission to know why the case was sent to them, but would not be definitive as far as the commission's own findings are concerned. The supplement, I will also in that supplement note why only a commission is appropriate in the circumstances and not a JIT. The respondent's argument that they have not been heard or might not be fully heard is not relevant in this case, because they will be heard before another forum, which is the one to decide whether to return a finding of the existence of a gang or not. I may also suggest additional TORs for the consideration of the government if it considers them appropriate to include as a consequence of the proceedings that have taken place before this court, which, on a quick thought, include the Commission's examination of the existing framework for the receipt, collection, monitoring, preservation and presentation of digital evidence, which requires an urgent and fresh approach to be taken in order to prevent and obviate, or rather minimize, the tremendous potential for abuse of digital evidence in comparison to physical evidence. Full stop. Further, I am also of the view that given the importance of this case, this court will exercise continuous mandamus and therefore will expect and therefore directs as follows. A copy of this, the government will constitute a commission within 30 days from today. Full stop. The commission will conclude its proceedings within 4 months, and should it require further time, it may approach the court for extension of time, subject to good cause being shown. Full stop. Disposed of accordingly. Thank you.
withdrawal का